Welcome back, everyone. So, today I'm going to talk about the origin and development of patent laws. This is a very short topic, so we'll complete it very quickly. So, let's move on to the ancient world, like from where this concept of patent emerged and what thought process led to the identification of patent protection. So, let's see that, okay? So, first one, you can find some evidence that some form of patent was recognized in ancient Greece in the city of Cyprus. The first statutory patent system is generally regarded to be the Venetian patent system of 1450. So, from the wordings, it's just clear that it is not a very established system of patent protection or anything like that. And also, patent protection was given for glass making for a period of 10 years. So, a natural or an organic need for protecting patents for protecting inventions was found or was acknowledged, and basically for the people who found out new methods, innovative procedures were granted an exclusionary privileges. So next one is, after so many years, in the 18th century Europe, during the Industrial Revolution, we know that the Industrial Revolution is that peak period of time, the glorious period, where a lot of inventions in the field of science and technology, soon after the Renaissance, was found. And during that period, there were a lot of inventions coming up, and many of the inventors wanted a privilege to use it, to make it, to reproduce it. And so itself, there were traces of patent protection found during the Industrial Revolution era. So, after some time, a legal battle was sought. Basically, it was initiated by James Watt. He invented the steam engine. So, the question was whether an inventive step, see, an existing machine or an existing invention, if it is modified so that its efficacy improved, its efficiency is improved, whether that particular process can be patented rather than just product. If you are improving the existing ones, can they be protected? So that was the legal battle that started around the year 1796, and it was established that the principle was established that the patent could be issued for improvement of already existing machines. And also, the English legal system became the foundation for patent law in countries with common law heritage. That means all the colonies of Britain had also followed the British patent system. In France, the revolution of 1791 caused the IP protections, or especially the patent protection, to come into force, and there no examination was done. So, if an inventor is coming up with a claim that he has invented something, then soon the patent was granted without any further examination or anything like that, because inventor's right was considered as a natural one. It is treated as an artistic gift. It is treated like a very natural gift, a god-given gift, so itself that cannot be questioned. So if somebody has invented something, then obviously he ought to be given some kind of reward for that. So that was in France. Now when we come to the ancient India, in ancient India, it is a well established fact that ancient India had acquired a high standard of proficiency in science and art. But however, the knowledge was kept as secret, or they were handed on to posterity through chosen disciples, and only the results were made available to the public. Basic thing is, not everything was equally or very well worded, or it was not well documented. We had the Gurukula Sampradaya, and then all these ideas or the theories or the intellect that the Guru had was passed on to the students through posterity. So it is basically passing on, the ideas were passed down through the brains, through the minds, and so you don't find any written documents or anything in favor to evidence this. This transformation or transmission of information or intellect from person to person. So as it is very obvious, there was lack of statutory protection to the inventor, and only the results were available. Only what is made is what is made could be seen, not how it is made. That how part is very well protected Protected in the sense that it is kept very confidential and not made known to the public. And all the knowledge is kept secret, as I said, because there is threat of theft, because anybody could copy it, because there was no protection. And because of this lack of statutory protection to the inventor, there was always a threat. And this led to the secrecy of knowledge, and the knowledge was either handed over to the favorite pupil or lost with the demise of the inventor. So many of the majority of the ideas and the intellect of the earlier scholars of India, the majority have been lost because when the guru dies, all the intellect that he has acquired in his lifetime also dies. So, likewise, the rich cultural heritage and even the intellectual heritage of India had been damaged and destroyed due to such a lack of statutory protection. So, only in modern times do we have legal protection for these kinds of inventions. Now, coming to the post British era, we find that no, before post British era, the British Patent Law of 1852, they provided the impetus for the British laws in India, even because India was a colony to Britain. And there we did not use the word patent, but we used the term exclusive privileges, and that also was given for a period of 14 years. Next one is it was modified into Inventions and Designs Act of 1888 because there were a lot of lacunas find in the British patent law. And next we have this whole Invention Designs Act of 1888 was repealed and a new one called Indian Patent and Designs Act of 1911 was enacted. But then after the post British period, after the British uh, like after India got independence, two committees were appointed, that is Patent Enquiry Committee and the Patents Revision Committee in 1948 and in 1957 respectively. And the second one, Justice N. Rajagopala Iyengar Committee, was more famous one, and they were providing a lot of revisions to be made to the Indian Patent and Designs Act of 1911, that is either to modify the existing act or to repeal the whole act and to bring a new act into being. So accordingly, Patent Act of 1970 came into being, and now we have the Patent Rules of 2003. So they are in view of fostering the growth of countries' indigenous scientific and technology capacity, like looking into the national interest and the public interest of a developing nation rather than protecting the interests of the inventors alone. And also, if you look at the latest position, we have the 2002 and the 2005 Amendments Act, which is in tune with the TRIPS Agreement of 1994 or 1995. That is a very important byproduct of WTO. And so in 2002 and 2005, a lot of amendments have been incorporated in the existing Patent Act so as to uh, recognize or acknowledge the India's acknowledgement or India's compliance towards the TRIPS agreement. So we look into detail about these amendments and how it impacted India, how LPG policies impacted the patent regime in India in the next few slides. So that's all for this lecture. We'll meet you soon with the next one.